Beckett provides a whole stack of legal advice around life and business, and today we're talking with Luke Stewart, who's going to give us some advice around employment law. Now Luke, when can an employer rely on a 90-day trial period?
Well, it's important for you to have a written employment agreement in place, and in that it must have some specific wording which talks about the fact that the employee cannot bring a personal grievance for unjustified dismissal if the employment is terminated within that 90-day period. It's also limited to 90 days, so no more than 90 days, and it must be negotiated in good faith with your employee, and it's a standard provision of all employment agreements. It must be the first time that the employee has been employed by you, so you can't do it with existing or staff that return to you for a second time. If you meet those criteria, then you've got quite a powerful clause as far as dismissing an employee, and it stops them coming back and claiming an unjustified dismissal. They can, however, come back and raise issues around unjustified action during the employment, or health and safety issues, or discrimination on the classic examples of race and religion, those sorts of things. So it's only around the dismissal that you're protected from. It's also very important to make sure that you have the employment agreement signed up in advance. Now that we've had this law in place for a couple of years, the cases are coming out showing that if you don't sign it up before the employee's first day, it won't be valid. A good example is an employee who was given an employment agreement a couple of weeks before their first day of employment. They read it, they didn't have any objections, and then they didn't get to sign it until morning tea on their first day. The employer then went to fire them a few weeks later because they weren't suitable, and the court said that it was invalid because the employee wasn't a new employee at the time they signed the agreement. They'd been there working, albeit for 2 hours. They were actually an existing employee. So the courts are showing that they are going to interpret it very strictly, and as an employer you have to be careful that you comply right down to the letter of the law with some of those little requirements.
So there's a lot for employers to know. What common mistakes can employers make? Yeah,
there's lots, and obviously it depends on the circumstances. But if you look at disciplinary action, those sorts of things, which is where we get involved a lot when either disciplinary action has occurred or an employer is looking to do it, they fail to provide the employee with enough warning as to the seriousness of the matter, and also often employers will prejudge the outcome before they know the full facts. I've had employers who will write a letter of termination and have it sitting there in their briefcase, have the meeting which they're meant to be fact-finding and making a decision, and then at the end of the meeting just hand the letter over. Clearly, when that's looked at by the courts, the matter was predetermined. The employer was always going to fire the employee, and the meeting was a bit of a sham, really. So it's important not to predetermine the outcome of any matter. And
when should an employer seek advice, legal advice?
Well, the lawyer in me always says do it early, but and that's not, well, that's sound advice, because often problems can be avoided if the correct procedure is followed. You can avoid a lot of the problems. We get a lot of employers come in and say, I've fired the person, I've done it all right, done everything okay, haven't I? And when you actually look back at just even the basic minimum sort of procedural requirements, they've not ticked some of those boxes. So the earlier the better, but at least before you make that final decision, I think you need to have had some advice on your process and whether the decision you're about to reach is a fair and reasonable one which an employer can make in all of the circumstances. And that's the test at the end of the day, whether it's fair and reasonable in all of the circumstances.
I'm sure we all have many more questions. How can we find out more?
Find us at 525 Cameron Road, or you can look it up on our website, www.hobec.co.nz.